Hi, everyone. So my name is Ashley Molson, and I am recording this video. This is going to be the first of many videos. This video is off the cuff. I have a notebook here of a bunch of points that I want to make about a very specific topic. But first I get into that, I'd love for you to know what to expect going forward on this channel. And if you are a new listener and you're starting with this video. So my goal is to provide education and very nuanced and detailed information about investing in real estate in New Jersey. And these videos are specifically tailored for investors. And the goal is to help give you education on strategies and also provide information about what could happen, how things will happen, if certain things arise during your transactions. And we're going to get really deep into certain things like worst case scenarios, contract terms, and all of that. So my goal is for you to be empowered, to feel like you have a better handle on the ins and outs of the intricacies of your real estate transactions in New Jersey, and to also have an understanding of the legal perspective of things. Now, I am an attorney in New Jersey. I am the owner of Molson Law Firm, LLC. We mostly work with investors, but we do also work with first-time home buyers and with sellers who are selling to first-time home buyers. And we feel that that makes us well-rounded in our ability to manage expectations, especially for our investors who are doing flips, because your ultimate buyer is going to be a first-time home buyer, most likely, or, you know, a 2 or 3-time home buyer in their lifetime, not an investor, right? So my goal is to bring all of that information into this channel, but it is unrelated to my law firm. This is educational purposes only. If you are a viewer of this video, you do not become a client of mine or a client of Molson Law Firm, and nor is the information being provided here legal advice just because it is being provided by a lawyer. So without further ado, we will get started with the first topic of the series that will be going forward. And all the videos going forward for now are going to be about specific contract terms. This one is focused on liquidated damages. So if you see me looking down, it's because I'm looking at my notebook that I wrote a bunch of things that I want to talk about with this clause. So liquidated damages, let's first talk about what it is generally. So liquidated damages is a tool, it's a mechanism that is put into real estate contracts or commercial contracts in general. And the way that it's used in real estate contexts is to allow both the buyer and a seller to establish a certain amount in dollars that they feel would be reasonable and sometimes not reasonable, but a certain dollar amount that they'd like to set aside in the case of the buyer breaching the contract, and that dollar amount will be held back as damages and given to the seller in order to help the seller avoid having to go to litigation to collect monetary damages if they are damaged or if the buyer defaults, not if they are damaged. Because if the buyer defaults, regardless of the damage, if there's a liquidated damages clause, the seller will get that amount. Just generally speaking, that's how it works. And typically when an attorney is working with first-time home buyers and first-time home sellers, and you're doing just your average residential transaction, liquidated damages clause is removed. It is clearly stated that the contract does not allow for liquidated damages. And the reason is because most people are not comfortable with the fact that if they breach, they will lose a certain dollar amount without having the chance to really speak for themselves. That's what court allows you to do. That's what filing a complaint and being able to answer as a defendant allows you to do. You can speak for yourself. With liquidated damages, it's kind of set in stone. It's pre-established and you don't have much wiggle room. So that doesn't sound too comfortable. But the purpose of this video is to explain why it can be used as a beneficial strategy for investors. So For investors, the way to look at it, one way to look at it is to see it as an exit strategy. And the reason is because most investment transactions come with a higher risk that that deal may fall apart. And the deal may fall apart for reasons that you don't have allowed for as cancellation rights under your contract. This could be because you didn't you didn't scope out the work properly, but you also agreed to buy the property as is, and you have no termination rights because of inspections, right? So in this case, you want to walk away from the deal because something came up that's so bad in terms of how much money it would cost or how much work it would take and time it would take to renovate. And you say to the seller, this thing came up and I can't proceed. And the seller's like, well, you told me you were purchasing as is, and you don't have any inspection rights in this contract. They're not as savvy, they're not going to say that so savvily, right? But you still want to walk away, even if they don't want you to, right? So if you have a liquidated damages clause in your contract, what's convenient about it is you can say, well, it doesn't matter to me because basically I get to breach and you can take X dollars and we can both be done with this. We already put this in our contract and I'm, conceding to the fact that I'm walking away and I don't have the right to in the contract. So we already prepared for this. Here's this clause. So it's uncomfortable because you're making it easier for the seller to basically take your money, but it's also comfortable because you're avoiding litigation and it allows you to resolve this issue that becomes a dispute basically so much cleaner, and it is like a clear pathway forward, in an event that you can predict might happen. So this becomes useful, especially when you have a lot of deals in your pipeline and you need to evaluate the risk that you have out on the street. So this could really be very practically viewed as you're looking at your spreadsheet of all the deals you have under contract. And you can even put in perhaps your system that you use, your app that you use, Podio or Monday, and you could add a note, liquidated damages clause here. If I breach, worst case scenario, I owe the seller X dollars. And that way you kind of know, like, you can measure your risk by the amount of deals you have under contract that all have liquidated damages clauses. You can add up all those numbers and you could say, all right, worst case scenario, I breach all my deals. This is how much I'd have to pay on all of them, right? So it just helps you evaluate and look at all of your deals from a risk management perspective. Now, it's not the only risk that you're taking that you might breach a contract, right? There's so many other risks that can come up in a real estate transaction that don't relate to this topic. So it's not a fail-safe viewpoint, but it is a helpful viewpoint and it is a useful viewpoint to have, and it allows you to have a mixture of color in your risk management. So that's one way to look at it. Now, let's get into, we're high level right now. Let's dive into some details. So what does the amount look like? How much is it? So the default provision that's often used is sellers' attorneys will often say the full deposit will be held as liquidated damages in the case of a buyer breach. Now, a lot of times my clients will say, well, I'm comfortable with putting X dollars amount down for the deposit, but I'm not comfortable with all of that being held as liquidated damages. So one element that can be added to your contract is making the liquidated damages like a smaller amount than the deposit. So let's say The seller really wants a $10,000 deposit. You could say, yes, that's fine, but only 5,000 of it can be held as liquidated damages. So that's how that would play out. The sellers might not agree to it. And there's also some additional layers to this that I'll add into this conversation, but just know that it's not set in stone. It doesn't have to be the deposit. Now, we did talk about before that you could avoid litigation because of this clause, but something to note here is that if you, let's say you do breach the contract and the liquidated damages clause gets triggered, if you refuse to honor it, then the seller can sue that you're breaching the contract twice. First, by your original breach, and secondly, by not honoring the liquidated damages clause. So just to add a little bit of reality check there, that just because this clause is there, you can't avoid litigation altogether and also not honor the provision. So just keep that in mind. Now, that's a good segue into just thinking about how the court would handle this if it did come into their world. So the whole point of liquidated damages is to avoid going to court. But if you do end up there, then the court has to look at a couple different things, depending on what is put into the complaint and the answers and basically who's saying what. But one of the things that the court has evaluated and has evaluated for years and years and years of time is what makes the amount reasonable. Now, there was a lawsuit that was filed a while back, and I will add a link to the document or a link so that you can download the document if you want to read the case about a person who I believe it was the seller, who felt that the liquidated damages amount was too small, that it wasn't sufficient enough. And so aside from some other things that brought the case into the court, one of the questions on the table was the amount being too small. So the court had to evaluate whether the amount was reasonable or not under the circumstances. And so they have a whole test that they put forward and a whole way of analyzing the amount. But basically, the court asks that the parties have had the opportunity when negotiating the amount to determine what they felt would have been reasonable at the time, what amount of damages would have been able to be secured as a reasonable amount given the possibility of the risk that lay ahead. So there's no like magic wand to be able to come up with like the perfect number, but the court wants to make sure that the number is not unconscionable, which would be like just an egregious number, something that is so astronomically like outlandishly high, and also on the flip side, unconscionably low or unreasonably low. So if the liquidated damages amount is $1, I'm sure even if you are the buyer, you could understand like why would any seller agree to that? It's unreasonable, right? So there's a little bit of a test that gets associated with determining if the amount was enough. The court will defer to the parties having the ability to freely negotiate with each other. But again, you want to think of it as like a test of what feels acceptable, like what hurts and what would feel good and make both parties like equally unhappy is probably the best way to put it. If you had a liquidated damages amount that was $1 as a buyer, you're like, yeah, that's awesome. If I breach this contract, I owe the seller $1. And then on the other side, the seller's like, $1? Oh my gosh, like that's terrible, right? Like let's say it was, the only thing that they were offered. But if you start kind of upping that number, right? And the seller's expectations start lowering, you kind of meet this place where both parties are like, okay, it sucks, but I'll take it, right? So you have to think of it that way. It's probably the best way that I could, put it, because it's really like it's a felt sense that you have when you come up with a number that is sufficient. Um, but you want to really think about it when you're a buyer of an investment property, if that amount feels egregious to you, and what you're willing and able to be comfortable with. And just know that if you refuse to honor it, that if it goes into court, it could get called into question. And there is a risk that the court might feel like the amount is too low because the seller may lawyer up and get smart in the case of that lawsuit, right, that they want to now argue that maybe the amount was too small because now they're going to court. So like, why not go all in? So you face a risk not honoring the provision. All right. So in the context where it's most useful to use liquidated damages, there's a couple ways to think about this. You have deals that you probably know for certain you're proceeding. You know that you feel good about it, you scoped it out, you've comped it, you've had your appraisals, you have, maybe you're assigning it, you have your end buyer lined up. Everything's ready to go, money's ready, cash is there. Like, we're doing this, right? In those cases, in those types of deals, which sound perfect, you may not want to offer the liquidated damages, or you may want to. It may just feel better to you to do that. But if you're measuring your risk and you feel that the risk is putting you in a position where on this one, in this type of a deal, you're just not feeling that clause and you don't want to put yourself out there with it, maybe in those deals, you might not want to, but it really depends on how you feel. I have some investor clients that's all, they just always do liquidated damages because it just feels better to know, like, this is it. This is what my risk is. I will honor it if something happens. It's definitely useful when you have a deal where you really might have to cancel it for a reason that the seller is not going to let fly. So obviously that's useful. It's also useful in your assignment contracts when you are assigning to an end buyer and they fail to perform, because then you have two layers of risk there. You have your contract with the seller and then your contract selling your rights to buy the property to, your end buyer. And if your end buyer fails to perform, you're going to want a liquidated damages clause so you can take that deposit to protect you from the exposure that you have on your original contract. So that would be a circumstance that you'd want to highly consider it. And then when you use this clause, what you want to avoid doing is making the language seem so broad that any cancellation is going to trigger the liquidated damages clause. And this ties into more your discussion and nurturing of the seller relationship. Sometimes sellers can be under the impression that if anything goes wrong, they can just take the deposit. And so as you communicate with the seller to hopefully get them to a place where they feel comfortable with you and you build trust, you don't want to use this as a trust building mechanism because it could set a false impression on the seller that no matter what, they can take your deposit and they can run with it. So that's a scenario that you don't want to create unnecessarily for yourself. And then secondly, If you feel like you are canceling for a valid reason under the contract, so you're not breaching, in your opinion, and the seller claims that you are breaching, that may be another exposure to possible litigation, because now you have he said, she said, which is usually where things go, or when things go to litigation. So the tightness of your contract and the clarity of your contract is very important to define what a breach is so that it's clear when liquidated damages comes into play. So other provisions in the contract can help support this provision in the contract. The frequency that I see this clause is pretty high when it comes to investment deals. As I mentioned earlier, it's very, very low when I'm representing my residential purchasers and sellers. Very rare, but it's very, very common to see with investment properties. It's hit or miss though when I have sellers being represented by counsel and the attorneys, depending on who they are and what type of work they do. If they do less investment deals, I always see them trying to add in rights to go to litigation if the buyer or seller breaches the contract. So that stylistically can affect whether we see the liquidated damages clause often or not. Now, this clause can get discussed at different times of the transaction process. So if you have tight paperwork and you have a contract that you know was blessed by your attorney, this is something that my office does. We help our clients like build out their contract paperwork for their deals. And it may already be in the contract that you have, whether, you know, it was attorney prepared by your attorney that you work with all the time, or maybe the template that you have has it in there. But if not, if you hire an attorney to help you take your contract and fix it up during like attorney review, for example, they may add liquidated damages at that time. But you may need to talk to your attorney about it because not all attorneys will just add this in as a default. I do. And then I ask my clients if they want it to stay. And we have this discussion about the importance of it, and pretty much everything that's going into this video, we discuss. But it's not going to just automatically be there because you're doing an investment deal. So you may have to bring this up to the attorney that is representing you. And so it'll come up during contract drafting, you know, at the latest. It won't come up after you're done drafting the contract. However, if you do have a clause in the contract that says that if you breach or if the seller breaches, either of you can sue each other in layman's terms, and you need to breach the contract, you could possibly offer, you know, to settle it out by giving like a certain dollar amount. But that wouldn't necessarily revert the liquidated damages clause into the contractual language. I mean, it's not going to happen, but it's something that you could still use as a tool. But it wouldn't be liquidated damages anymore. It would be more of like a settlement offer. It would be different. So when you're negotiating this, how often will sellers agree to it? Typically, if you're working with a seller and you're getting a contract drafted and signed and it doesn't need to go into attorney review, then most sellers will just agree to it because it's in your contract, and they're like likely going to read the clause and see, okay, if they breach, I can take X dollars. That's great. But if they have counsel and if the contract is going to be amended, they may have an attorney who convinces them through their advice, which I'm not saying is right or wrong. I'm not commenting on it at all, whether it's a good thing or a bad thing, but they may like suggest to the seller that they have rights to pursue litigation and that they don't accept the liquidated damages clause. We have seen that before. It's happened not just once, but many times, that a seller's attorney would add that type of a clause. So just be mindful that you may want to use this as a strategy, but it might not always fly depending on who the seller's counsel is. And so there are ways to try to get the seller's attorney to see that maybe there's value to it. It can be adjusted. Maybe you can up the dollar amount. Maybe there's certain ways you can explain it in terms of language, and this would be something that I would be doing on your behalf. But just know that it's possible that in negotiation that this strategy can't be used because the seller's attorney won't agree to it. So the next thing to think about is, well, what if the seller breaches? Do I get a liquidated damages clause too? That's a common question that I receive from my clients. And unfortunately, the seller can't be asked and is never asked to put up a deposit. They're essentially locking themselves into working with you and you only, they're preventing themselves from accepting other offers. So there are other kind of expenses the seller has that don't necessarily have dollar amounts associated with them. But if the seller breaches, it should be made clear what your rights are in the contract if they default, which would typically be to pursue litigation or equitable damages through specific performance, for example, which would be like forcing the seller to purchase the property if you felt like they were not performing. I will be recording a video about specific performance and chatting about a real deal that we had that went to specific performance for a seller that ghosted and didn't show up for closing. So just keep in mind that your rights will kind of be that general term that provides for the right to pursue litigation. And then the next thing is, when is it worth avoiding this clause? So as I mentioned earlier, it's not necessarily a clause that you want to avoid. But if your cash flow is tight and you have a lot of deals in the pipeline, and you feel that, if you do breach, that money, that outlay would be like a big chunk for you of your cash flow going out the door, you could decide that you want to force the seller to have to go to litigation, because the idea of going to litigation, it has its own upfront cost associated with it. You may feel that the risk of the seller doing that is low. And in this context, just looking at the big picture, you may feel that it'd be a bigger risk for you to put this litigation or this liquidated damages term into the contract. So that's a little bit more of like a nuanced, sensitive way of looking at the big picture and how it impacts you. But something to consider is the likelihood of the seller actually going to litigation. And if you can work within the contract to make it very clear, like what a breach is and what a default is and when litigation would be able to get triggered, then, you may feel that just it's more protective for you not to use this clause. So just something to digest and think about. So another nuance is, where is the deposit? Because typically the liquidated damages clause ends up being either the deposit or some amount less. It's very rare that it's more. I don't often see that. And the reason for that is because the seller would have to then try to collect the additional amount. So they normally won't agree to it being more because it's more frustrating, although it would be better for them. but it's like, how do you get it, right? Well, it's nicer to know like this money's in escrow and it's sitting there. So in most real estate transactions, it doesn't matter who's holding the deposit, whether it's the buyer's attorney, the seller's attorney, or the title company. Everybody has to, in theory, manage the money like an escrow agent. So they have to take off their attorney hat and look at it, look at the deposit, and they have to be impartial and unbiased about how that deposit is handled. So it makes every attorney's job a little complicated because when they're advocating for you, they're doing so as your counsel. But if they're about to go release the money from the escrow without getting approval from the other side, are they doing that as your advocate or are they doing it as an unbiased escrow agent? So that can be nuanced in its own realm. There could be an hour discussion about that and the role of the attorney as the escrow agent. But let's just say it's a little bit easier for the seller to get the funds if the funds are in the seller's attorney's trust account than it would be if the funds were in the buyer's attorney's trust account. But all attorneys' hands are generally tied, and same with the title company. Any escrow agent's hands are kind of tied in making decisions about what to do with that money that don't align with the contract. So if it's clear that the contract has been breached, just because your attorney is holding the deposit, they can't just prevent the release of it. We have seen, though, sellers' attorneys hold on to deposits and then release it to the seller improperly. That has happened. So there's a little bit more risk with the deposit being held by the seller's attorney. So typically we tell our clients to have the title company hold it because they're usually very nervous about breaking any rules, being held liable for things, their errors and omissions insurance being put into effect and getting triggered and things like that. So we like stylistically, just by our preference, to have the title company hold it because it allows both seller's counsel and buyer's counsel to do the arguing, and the title company will just kind of wait until a resolution is reached. So next, this is a question that I was asked. So reading this from my notes here, what if I never submitted my deposit and the seller holds me in breach and I have a liquidated damages clause? So then what happens? So in this case, if you've never even made your deposit, there's a couple problems here. One is you could be in breach for not making the deposit. There's, an argument there. And then secondly, you're in breach of not honoring the liquidated damages clause, in this hypothetical, which is obviously very, very black and white hypothetical here. And you are now kind of exposing yourself to, again, the seller possibly pursuing litigation because 1, the deposit was never submitted, 2, you're breaching, and 3, the seller's demanding the funds. So, yeah, there's a risk there. You're taking a big risk, and that would be a situation where you may want to seek counsel if you don't have counsel, so you can determine what you need to do in that case. So you can get the gist of what I'm saying here. It's pretty clear, based on, what I've said already in this video, like what would need to be done here. Just the fact that you didn't make your deposit already, puts you in a troubling position in that case. So if you want your attorney to start adding this clause and utilizing this in your business, what do you say? How do you let them know you want to add this? You could let them know that you are interested in adding liquidated damages clauses to your transactions, either if they could help you update your contract or if they could add this to your attorney review templates. Hopefully they have a template for you that's specific to your business because they probably know like what you like to do, what you like to agree to, what you don't. just have a chat with them, let them know that this is something that you're interested in adding, you feel like it would be a useful exit strategy for you. And you could also ask them for their advice, if they could talk to you about the risks, the rewards, have a discussion about it, and be transparent with one another about when you feel like you might want to start using this and your comfort level with it, etc. So this could be a whole like, strategy call that you could ask, you could have with your attorney. It's something that we've done with our clients, and we tend to have this discussion early on when we bring in our new clients into our firm. So it's something we want to know. We want to see and know if we're adding this in. It's if you were a new client to the firm and you sent me a contract, it's one of the first questions I'll ask you. Do you want to add liquidated damages to this contract? And then we would have a chat about it. So as I mentioned before, it's not the only exit strategy. This is also not like a fail-safe thing. It's not the only risk you're taking in a investment deal. Of course, there are other exit strategies. So I will post future videos on other exit strategies. But the limitations that this has, as have been discussed in the video already about the exposure to litigation risk, that still is there if you're not honoring the provision, if you feel like you haven't breached, but the seller feels like you breached the contract. If for some reason you come up with an amount and the seller doesn't feel like it's enough, or maybe you come up with an amount and you feel like it's too much. Let's just say you breach the contract, right? Here's a perfect example. You breach the contract, you have a $5,000 liquidated damages clause. The seller takes the $5,000 because you agreed to it, you said it's okay, they can take it, and you move on with your lives. Then you go and you see that a deed was recorded for a new purchaser and the seller sold the property for like $70,000 more. They didn't have any damages, you might say, right? Who knows, exactly what the impact was on the seller. There's a lot more that can go into those details, but let's say they didn't have any damages. Let's say they made out, better. And then you may want to sue the seller for having taken that liquidated damages clause. But at the time that you negotiated the contract and at the time you breached the contract, it may have been reasonable that the $5,000 was used and given to the seller to accommodate for your breach. So there's a risk there as well. And then if you're a seller, let's say you're selling a property to another investor and you want them to agree to liquidated damages clause, can I or you ever expect a buyer to agree to liquidated damages clause? Yeah, probably. And if you're selling to another investor, but if you're selling to a first-time home buyer or a second-time home buyer or a residential purchaser, probably not. They're likely not going to be able to stomach it. Maybe, but the chances are highly likely no. And if there are any other provisions that interplay with liquidated damages that could enhance it or make it riskier, yeah, the type of clause that could enhance the liquidated damages clause is the definition of what a breach is. So you can very broadly narrow the definition, making it pretty much like open-ended, that any cancellation that's not for these very specific reasons that are clearly laid out in the contract is a breach, or very specific reasons are breach. And then we also have these other exits. So there's definitely other strategies in drafting that can be utilized to make this liquidated damages clause more protective for you.